Are you Caleb Jubert?
Smile.
And Mr. Lewis, will your client waive the formal reading of the indictment in each case?
He does.
Mr. Jubert, in cause number 25, DCCR 1130, you're charged with the state jail felony offense of unauthorized use of a vehicle from July 3rd of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
No.
And then in cause number 25, DCCR 1131, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from July 3rd of 2025. And how do you plead to that charge?
Yes.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
In each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like, let me get to this other one real quick. So it looks like the agreement that you've reached in each of your cases is for a 5-year deferred probation in each case. It looks like there would be a $500 fine in the unauthorized use of a motor vehicle and a $300 fine in the evading arrest or detention with the use of a vehicle. You would be required to enter and successfully complete the cognitive track of the ISF program, in addition to being on the specialized mental health caseload. Is that your understanding of your agreement?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection, Judge.
It's admitted in each case. Is there any evidence that Mr. Jubert's not competent?
No objection.
All right, Mr. Jubert, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of those pleas, find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing.
Yes, ma'am.
Are there any reports?
Judge, and may I just put something on the record very briefly? Mr. Lewis and I think are very much on the same page that we don't want this young man, hopefully, to have a felony conviction at his very young age. Maybe try to get him on the right track with ISF. It's my understanding he's kind of expressed some hesitancy with being on probation and may have wanted to just do time. So I would just ask him to think about it while they're doing that PSI. If he really didn't want to go this direction, we can discuss an alternative offer. I don't want him to take another young man's spot in those programs, but I really hope that he wants to avail himself of not being a convicted felon.
You understand what Ms. Malfino is saying?
Yes, ma'am.
That's what we all want, really. And we hope that you would want that for yourself, is because if you just take a deal and get some time and go do your time and get out, may be easier, may not, but in the short time, it's maybe easier. But in the long run, for the rest of your life, you're going to regret that because you're going to be a convicted felon. And that changes your life so negatively in so many ways. You can't live certain places. You for sure can't get lots of jobs you can't get and things like that. So you got some time where the probation will come out and talk to you. Think about that. It looks like you're doing well in jail. There's no incident reports. I've been telling everybody I'm fussing at half the people today, but I appreciate that you're behaving and following the rules. Continue doing that. What that shows me is that you have it in you to be very successful on probation. You just kind of got to get in the right lane and go the right direction. All right. So we'll see you back at sentencing.
Thank you, Judge.
Thank you, Ms. Malfino.
I need a comment.
We need him for a.
One more.
Good morning. Are you D. Antonio Riggs?
Yes, ma'am.
This is 25 DCCR 0975. I am going to take judicial notice of the court's file, Mr. Riggs' case. Mr. Riggs was evaluated by Dr. Hamza for competency to stand trial. I received that report, dated, let me get to it. The examination date of January 27th of 2026. The finding in his report is that Mr. Riggs is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Judge, nothing to finish.
No, Your Honor.
Then at this time, based on that report, I am going to find that Mr. Riggs is competent to stand trial. Are you ready for an announcement, or do you need some time on that?
A little, Judge.
Okay. I'll just do a normal reset. If something happens and you want to move it up, just let us know.
Okay.
Mr. Riggs, Mr. Lewis will be out there to visit with you about your case and what your options are, and we'll get an announcement at that next court date. All right?
This is where it gets real. When a judge brings up your age like that, it's not small talk, it's a warning. She's basically saying you're old enough to know better. Trust me, juries notice maturity, or the lack of it. Interview.
Eric Segrist, Mr. Lewis.
Yes.
Good morning. Are you Eric Segrist?
Yes, ma'am.
And this is cause number 25, DCCR 1836. Mr. Segrist is charged with burglary of a habitation. And what is the announcement?
Judge, this was one that we had reset here from a few weeks ago where Mr. Smith was trying to reach out to the complainant in regards to this case, some paperwork that she supposedly had came and filed with the DA's office. To date, my understanding, he has not been able to get with her. I've tried to call her, but hasn't gotten any answer. I've got a separate number that supposedly is supposed to be good to reach out to her. I've given that to Mr. Smith. And of course, we're asking for a little time to see if we can do that. I've talked to my client. He did want me to ask about possibility of a bond reduction.
Well, let's do
regards to
this
this.
because that would make sense if you can't get in touch with her. I'm going to reset it 1 week. Mr. Smith, see what you can do with that new information, and let's get an announcement next week. If for some reason you can't get in touch with her, but the state's going to proceed with the case, then we'll talk about a bond next week.
I'll file a motion to that.
Perfect. Thank you.
Right
All
there, that's judicial power. 6 months per incident stacked. That means every write-up could literally add time. This isn't just a warning, it's a countdown. So the question is, does he take it seriously?
All right. We'll see you next week.